Good day everyone, I'm Dennis here from Group 15 with Panchanyal, Arul and Ashmita Nathan. We will discuss and examine the theories that apply in order for the courts to effectively discharge its duty of securing good administration from the executive. We will also examine the most effective theory for the courts to apply when addressing a hot topic currently in the UK, which is the government's policy on the refugee protection and the need to balance it with associated risk as a result of improved treatment by the government towards refugees. So let me start with the introduction. Ivor Jennings defines that the administrative law as the law relating to the administrative authorities. Administrative law focuses on assessing the legality of government actions. There is a twofold analysis: the legality of the specific policy itself and the legality of particular acts purportedly authorized by the policy. Governments act through public officials who must act within certain limitations, since the authority to act stems from the Constitution and/or legislation. Thus, government officials must act within the parameters of such legislation which give their actions lawful authority. The English courts have strived to uphold good governance. Good governance relates to the processes of decision-making and implementation. Rather than merely making correct decisions, good governance explores the best possible process for making those decisions. Good governance has 8 major characteristics. It is participatory, consensus-oriented, accountable, transparent, responsive, effective and efficient, equitable and inclusive, and follows the rule of law. It assures that the corruption is minimized, the views of minorities are taken into account, and that voices of the most vulnerable in society are heard in the decision making. It is responsive to the present and the future needs of society. In the duty of securing good governance from the executive judicial review, represents one of the means which by the courts achieve this. Achieving good governance through judicial review is made possible by embracing a number of theories. These are the rights-based approach, separation of powers, principle of relativity, the red light, green light theory, and natural justice. These theories influence the way in which the judges approach a decision of the government to ensure good governance. I will start by introducing one of the central theories which judges apply deciding on an application for judicial review, which is the rights-based approach. As stated by John Lawes in a string of celebrated articles, judges play an important role in the protection of fundamental rights. He presented a rights-based approach concept of law and stressed the importance of the judiciary in protecting fundamental rights. He also asserts that the rule of law can be assimilated with an attachment to freedom, certainty, and fairness. These words can be attached to Dicey's 3 postulates of the rule of law. In particular, freedom, which aligns the third postulate, our rights are safeguarded by the common law. Essentially, Taking the rights-based on approach means a judge decides based on what is right according to fundamental rights and the rule of law. An example of the rights-based approach is the concept of proportionality. The concept of proportionality is a European concept which ensures the exercise of powers by authorities is proportional to the objective being pursued. The concept was first applied by Lord Jennings in Ex parte Hoc, though it was not explicitly referenced thereto. Furthermore, in CCSU, the House of Lords accepted the proportionality might emerge as the further grounds for review. This eventually happened with the test of proportionality established in De Freitas and applied in Ex parte Delhi. This expands the grounds for judicial review beyond the traditional Wednesbury unreasonableness. The enactment of the Human Rights Act 1998 further enables judges to take the rights-based approach. In Secretary of State for the Home Department against Nasri, Lord Hoffman states that when an application involves an alleged violation of the convention right, the court's approach must differ. The focus is not on the whether the decision-making process is defective in law, but on whether or not the applicant's convention rights have been violated.
Hi, I'm Chin Yao and I'm gonna talk about the content one. So, separation of power is another central theory which judge always have in mind when adjudicating. And the government make effective, open, prospective, stable, general rules for the community, and the judiciary must be independent in resolving dispute over these rules. Besides that, famously stated by Montesquieu, there can be no freedom if the judiciary is not independent. So separation of power is maintained toward the concept of justiciability, which was introduced in CCSU. The law Roscoe laid out 6 matters which are unreviewable, namely, so the first, the appointment of minister, the dissolution of parliament, the granting of honors, defense of the realms, and the prerogative of mercy and treaty-making power. Next, the principle of relativity in administrative law is a contextual approach where the court made a decision based on the particular circumstances of a case and considerations such as public and social context. The way in which the court make a decision depends on factors such as the type of power being exercised, the nature of the body, the process by which it acts, and the way the decision affect particular people such as the individual and the community. So for example, of the principle of relativity, being applied is the Wednesbury unreasonableness test, because what is deemed so unreasonable that no reasonable authority could have ever come to it is largely dependent on the circumstances of the particular case. Additionally, when determining the rules of judicial control over public administration with an intent to secure good governance and prevent an abuse of power, so there are various schools of thought that question whether the executive action should be brought under strict judicial control or executive action should be independent of judicial control. The traffic light theory of administrative law help in understanding all these discourses. The red and green light theories in administrative law was first introduced by Harlow and Rowling in 1948 to assess the objective of administrative law. So the red light theory highlight the skepticism towards executive power and sought to minimize the encroachment of the state on the right of the individual. So the concept of parliament sovereignty, as explained by Dicey, introduced the idea of the red light theory. He assessed that the government is required to operate within the confines of legal routes established by parliament and under circumstances where the government does not. The court have the authority to proceed with lawful action, and the green light theory emerged during the World War period. It argued that administrative law should be used as a way of facilitating the operating of the state rather than controlling it. Besides that, as society has become more complex, it is argued that the court should endeavor to take a less restrictive view of administrative action. Supporters of green light theory believe that political and democratic forms of accountability are preferable to the court. So the Wednesbury unreasonableness test is an example of the green light theory in administrative law, as it is generally pro-public authority. In response to these two schools of thought, a third way has been advocated, which is the amber light theory. It lay between the red and green extreme and suggests that the approach to be taken should be determined on a case-to-case basis depending on the circumstances of the case. So the amber light theory stresses the importance of control inside and outside the court for effective public administration. Another theory of administrative law stems from the notion of not only should justice be done, but it should also be seen to be done. The roots of natural justice are common law roots that are as ancient as the justice system itself. So the embody two principles, the roots against bias, nemo iudax in causa suat, and the right to a fair hearing, audi alteram patrem. The roots of natural justice form the second category of instance where a procedural impropriety may occur, and it acts as a safeguard against administrative action that could negatively impact the right of individual. So a landmark case on this point is Rich vs. Bowen, where Rich, a chief constable, was dismissed without being given notice of the charge against him or a charge to be heard before his dismissal. So the House of Law held that the committee had violated the rules of natural justice, as they had a duty to hear the other side, and his dismissal was ultra-virus.
In the task of evaluating the most effective theory to be used when addressing the government's need to strike a balance between the protection of refugees in the UK and certain associated risks, such as the opening of floodgates that would result from improved treatment by the government towards refugees, it is crucial for the courts to determine the central issue in regard to the given situation. Here, it is the balance of the refugees' fundamental rights, such as Article 2, the right to life, Article 3, prohibition of torture, and Article 5, the right to liberty and security, and the government's interests, such as the need to regulate immigrations, manage resources, ensure national security, and meet public interests. With these issues in mind, we believe that the most effective theories when approaching these issues would be a combination of the rights-based approach and the principle of relativity, for the following reasons. When taking a rights-based approach, the judge will make a decision based on what is right according to fundamental rights and the rule of law. Particularly, the third postulate of Dicey's rule of law, our rights are safeguarded by the common law. With the potential infringements on convention rights, which is a hard-edged issue, the courts would apply the concept of proportionality to strike a balance between the protection of refugees' rights in the UK and associated risks such as the opening of floodgates. The concept of proportionality was first introduced into domestic law by Lord Denning in R. Barnes against Barnsley, Metropolitan Borough Council, ex parte Hook. The doctrine entails the decisions made by an authority must be proportional to the legally based objectives they are trying to achieve. With the rights-based approach in mind, the judge would be more inclined to scrutinize the government's decision to ensure the protection of refugees. This also aligns with the principles of the red light theory because one of the fundamental tenets of this theory is the courts are the primary weapon for protection of individuals and control of the executive. A rights-based approach allows the court to ensure the government complies with the obligations under the HRA 1998 and the UK's obligation to the ECHR when dealing with refugees. Judges also act as guardians of fundamental rights, and a rights-based approach allows them to exercise this function in relation to refugees. For example, the court may decide in favor of the refugee to prevent refoulement. Refoulement means refugees that are forcibly removed to their country of origin face threats to their life and ill treatment as punishment. Removing a refugee who faces the risk of refoulement would be a breach of Article 3 of the ECHR, and judges are bound by Section 6 of the Human Rights Act 1998 to ensure that Article 3 is not breached. This may be observed in the case of RAAA and others against Secretary of State for the Home Department. In this case, the application arises out of claims brought by individual asylum seekers who travel across the English Channel in small boats. The Home Secretary declared the asylum seekers' claims to be inadmissible and they should be removed to Rwanda. This decision was made in accordance with the Migration and Economic Development Partnership between the UK and Rwanda. Pursuant to paragraphs 345A to 345D of the Immigration Rules, if the Home Secretary decides that an asylum seeker's claim is inadmissible, she is permitted to remove the person who has made the claim to any safe third country that accepted the asylum seekers. Here, the Home Secretary decided that Rwanda was a safe third country for the purpose of these arrangements, and this was dubbed the Rwanda policy. The asylum seekers challenged the lawfulness of the Rwanda policy generally and the Home Secretary's decision to remove them to Rwanda. At first instance, the Divisional Court held that the Rwanda policy was lawful. However, the way in which the Home Secretary implemented the policy was procedurally flawed and the decision was quashed. On appeal to the Court of Appeal, the court only considered the lawfulness of the Rwanda policy generally and allowed the asylum seekers' appeal on the grounds that the deficiencies in Rwanda's asylum system were such that there were substantial reasons to believe that there is a real risk of refoulement. In light of this, Rwanda is not a safe third country. If the deficiencies in Rwanda's asylum system are not corrected, it would be unlawful pursuant to Section 6 of the HRA to remove asylum seekers to Rwanda. This is because the risk of refoulement would be a breach of Article 3 Prohibition of Torture of the ECHR. The Home Secretary then appealed to the Supreme Court. The court unanimously dismissed the Home Secretary's appeal and upheld the decision of the Court of Appeal that the Rwanda policy is unlawful. The grounds for this decision were 1. Rwanda has a poor human rights record, 2. Systematic defects in its processing, and 3. Under a similar agreement with Israel, Rwanda removed asylum seekers to their countries of origin. Due to this evidence, there was a real risk that the refugees would be returned to their countries where they would face ill treatment and thus be a breach of Article 3 of the ECHR. This case clearly reflects a right-based approach taken by the judges in ensuring that the convention rights of the asylum seekers pursuant to Article 3 were protected. The decision of the Supreme Court was widely regarded as a decisive loss for Rishi Sunak's government. Although there are arguments against the right-based approach due to the potential for judicial overreach, in this instance, it proved to be an effective way to ensure the government does not create policies that impact the substantive rights of refugees and said policies are adhered to.
Since a balance needs to be struck between the protection of refugees in the UK and the potential associated risks, the principle of relativity should also be applied. The approach taken in relation to the principle of relativity is contextual. The courts looked at the circumstances of a particular case, and the decision of the court depends on all the factors to decide whether they should make decision in favor of the public authority or the applicant. The contemporary setting of administrative law in the UK has always required the judges to delicately balance a number of elements like public debt, social fragmentation, economic and financial challenges threatening national welfare states. And doubts about international problem-solving capacity. With this in mind, the principle of relativity allows judges to consolidate practical consideration and legal principles. For example, the government decides not to grant citizenship to refugees in the UK due to the floodgate argument. The court will take this into account when deciding whether the government's decision was lawful or not. In this situation, the government's decision will depend on factors such as public perception and the way the decision affects particular people, the individual, and the community. Public perception plays a major role in the way refugees integrate into the community. If it is negative, the refugees will not be able to contribute economically and socially, leading to a higher level of unemployment and increase in crime rates. This may lead to the court deciding in favor of the state instead of individual. Furthermore, the government's decision also depends on resource allocation and capacity. Granting refugee citizenship in the UK requires infrastructure, housing, and support systems such as medical care. Accepting refugees would put a strain on local council and the use of contingency accommodation like hotel due to high asylum application backlogs. This is the situation in North Ireland, where the high number of asylum seekers being accepted into the country has caused a housing crisis, and there has been publicly outcry which has led to riots and raids. Additionally, national security is another area of concern which the government takes into account when dealing with refugees, particularly if the refugees come from wartime countries or conflict areas where terrorism activities are high. The threat to national security is also high. For example, in the case of Pham against Secretary of State for the Home Department. In this case, Pham was born in Vietnam but acquired British nationality. The Home Secretary made an order under Section 40, subsection 2 of the British Nationality Act to revoke his citizenship based on evidence that he received terrorist training in Yemen. However, Section 40, subsection 4 of the Act states that an order under subsection 2 cannot be made if the person becomes stateless. After the Home Secretary made the order, the Vietnamese government made a declaration that Pham was not a Vietnamese national. The Supreme Court dismissed the Pham's appeal that he would be stateless if his citizenship is revoked, because at the material time the order was made, he was a Vietnamese national, and the declaration by the Vietnamese government that he was not a Vietnamese national could not work retrospectively. This case illustrates that if national security is at risk, the court are inclined to decide in favor of the decision of the government. National security is also one of the 6 non-justiciable matters laid down by Lord Roskilde in CCSU. Thus, embracing the principle of relativity, these factors and circumstances will be taken into account by the court when addressing the government's decision relating to refugee. The court may decide difference is appropriate where the governments enjoy discretionary area of judgment. This also aligns with the green light theory. So, the conclusion is the issue of refugees in the UK is a sensitive matter, as on one hand, there is a need to protect refugees due to the UK's international and humanitarian obligations, and on the other, there are domestic concerns which the government must take into account as well. The courts must take a balanced approach, and we have concluded that the best way to achieve this is a mix of theories, particularly the rights-based approach and the principle of relativity, because a rights-based approach allows the courts to recognize and uphold the fundamental rights of the refugees, and this is balanced with the principle of relativity, which allows for a context-sensitive approach to ensure all factors are taken into account to meet the needs of the circumstances. Together, administrative bodies are able to strike delicate balance between the protection of refugees and the international human rights obligation with pragmatic consideration to prevent refugee protection from becoming unduly burdensome on the government. Thank you.